DeChristofaro, who is the Registrar of the Probate and Family Court for Middlesex County. And she will present an informative overview of the new Massachusetts Uniform Code, which took effect on March 31st, 2012. And I'm sure you're saying, why should I be interested in that? It is a mouthful. Anyway, but this code will have an impact on Winchester seniors and their families now and in the coming years. The new code offers new options for a faster, less complicated, and less expensive procedure to probate a will, or if there is no will, to administer one's estate. So let me tell you something about our registrar, and she will fill you in on this whole thing in great detail. She's a graduate of Yeshiva University and has a law degree from the Cardozo Law School. She's a member of the Massachusetts Bar Association and the Middlesex Bar Association. She has been a former Middlesex County Assistant District Attorney, and she has been Deputy Assistant Registrar for Middlesex County. In 2009, she was elected to a 6-year term as the Registrar of the Probate and Family Court in Middlesex County. And we are delighted that she's come here today, and I'd like to welcome you back.
So thank you for having me today. Thank you, Ruth. I'm here with the Winchester native, John Toomey, who made his home in Winchester. I am originally from Medford, born and raised, and Jack was originally from there and has since come over here and settled in and raised his family and his grandkids now. So I'm very glad to be here. You know, a couple of things I want to do today is tell you who I am, what I do, and how this Uniform Probate Code may affect you. And who I am as the Register of Probate. And for any of you who don't know, that is the clerk of courts for the Probate and Family Court. The Probate and Family Court deals with people, as we say, from birth to death. It deals with adoptions, people who legally want to change their name, any domestic relations activity in divorce, custody proceedings, paternity establishments, child support orders, wills, people who die intestate, trusts, guardianships, conservatorships, which are guardianships over someone's estate while they're living, guardianships of minors, and we are a court of equity, and that is when there's no other remedy at law, you can come into the Probate and Family Court and seek equitable relief, something that's fair. The reason this seat is elected, and just a little bit about the seat, is that it's the oldest constitutional office in the country. And it originally came to be when the judges from the Crown used to come around and dispose of matters throughout the colonies, and they decided they wanted someone separate from them, keeping the record of what the judge ordered. And it's really to protect the people from overreaching and maybe some tampering. So it is the only person that is 100% responsible and responsive to the people who put them there. So, you know, everyone's in there to do a good job, but the baseline of why the seat is an elected seat and not an appointed seat was particularly that purpose, to keep the lines of who makes the law and who puts the law in place, and who makes the decisions and who writes down what the decision actually is to different people, and protects both sides really from any sort of undue influence. So I think I covered what we do, and if any of you know about Middlesex County, it's I think it's like the 14th largest county in the state. I think it's bigger than, in the country. It's bigger than 13 states per capita. And it goes as far up as Ashby, along the New Hampshire border to Dracut, over to Groton, and in the Marlborough area, and down in the inner belt in these local cities and towns here. And it contains 1.6 million people. We do 27,000 filings a year, and that is over 6,000 new probate estate cases and over 5,000 divorce cases a year. So, you know, I usually do this thing where I have people close their eyes and raise their hands, but nobody really likes to do that because they think someone's looking at them and pointing at them and making fun. But just for your own purposes, I want you to think about if you have a will. And I want you to think about if you have a trust, if you have a healthcare proxy, and just understand that if you haven't gone to see a lawyer to protect your assets, you're leaving it up to the government or somebody else to decide what happens to your life estate, what happens to your life's work. So under the Massachusetts Uniform Probate Code, it's been about 10 years in the making, and it finally went into effect. It changes a number of the ways that we process the paperwork, and it changes the laws governing intestate succession, which is when someone passes without a will. The court or the statute determines who's entitled to the monies. Under the prior law, if someone passed away with a spouse and children, they would have, that the spouse would get up to $250,000, and then half of the remaining estate. And the children would split the other half. Under the current law, as it stands since March, if someone dies with a spouse and children only of that marriage, and what this does is take into account blended families, a lot of divorces, remarriages, children, stepchildren, all that kind of thing. If there's an intact family, surviving spouse and children, that spouse is the only heir at law and takes the estate. And the premise of that was both parents would want to see their children do well, and that parent, the surviving parent, would provide for their children. When it becomes questionable now, this is not how it was in the past, if there is a blended family and someone has brought a child in from a prior marriage or a prior relationship, and they pass away, that spouse is now no longer the only heir at law. That spouse and their children, as well as the child from the prior marriage or the prior relationship, are heirs at law under the statute. So your amount that the spouse is entitled to receive if the person passes without a will is different than it used to be. And it protects the child from the prior relationship, from perhaps the step-parent not caring so much about their well-being as their own child. So you can see why potentially that was put in place. So when we talk about a will, we talk about your ability to really say who's going to get what. You don't have to give a reason why, you just have to give your money or your estate to whomever you choose and not have someone else tell you what to do or tell your children what to expect from your estate. We want to talk about some common mistakes in drafting a will and some things that you can do to protect yourself, and things that you should make sure are in place when you draft a will. You want to make sure it's signed, obviously, but you'd be surprised that they come in not signed. You want to make sure it's dated, because if you've had 2 or 3, if your last one isn't dated, it's just not the last one, is it? That it's witnesses by 2 adult persons. And that all pages are initialed or signed. And we like to say in the court, it's best if we see a will that says 1 of 5, page 2 of 5, page 3 of 5, because truthfully 3 months ago, we had someone submit a will, and because it didn't give them the ability to sell the property in the will, someone substituted another will, forged the name, forged the witnesses' signatures, redated it, and put it in the folder as if it was the testator's last will and testament. Luckily, we scanned all our documents, and we had the original at least scanned, and we could reproduce it, and the judge since fixed it. But we are a court of public record, so it's being seen by everyone and anyone, and tampering does occur. So what they really tried to do was slip in a 4th page. It was a 3-page will, and then it all of a sudden became a 4th page, a 4-page will. And the clearer your will is, the better, as obviously. And you want to make sure that all the signatures are notarized. Another thing you want to make sure is the person that you're going to appoint, what used to be called an executor or executrix, which is now called a personal representative, you're going to want to make sure that that person, if you've asked them, and I'd like you to oversee, because it is a large responsibility to distribute someone's estate, And also make sure that you have a successor appointed, because between the time you create the will to the time you pass, the person themselves may have deceased or become incapable of administering your estate. So you want to make sure there's a successor named in the will. And most importantly, we think, is to make sure that you leave a list of where all your most important documents are, whether they're in the attorney's office, in a safe deposit box, in the file cabinet upstairs, or, you know, under the rug, under the bed, in a little, you know, metal box. So someone needs to know where that is. Leave a list somewhere. I can't tell you how many times that we've had attorneys' offices, the attorney passes and their papers go to another office, and then people, you know, someone's child or grandchild doesn't know that that's the attorney that drafted the will, and they can't track that will. So it is important that you keep track of where your most important documents are. The other thing is if you execute a will, it's not necessarily required that you re-execute the whole thing. I'm sure some of you have heard of codicils. And what a codicil does is can amend the will or add to the will, and that needs to be executed in the same way we described: signed, witnessed, notarized. And once it's done so, it becomes part of the original will. It's added on to the back, but it's all encompassing. It's read together as a whole. You can make some changes if you find, let's say, your personal representative has deceased. You can actually amend that part of your will with the codicil. The court also takes in wills for safekeeping. There's a $75 fee, but what happens is a testator can come in, file their will, it stays under seal, and the only people who can access that will are either the testator during their life, showing an identification, or the named executor or personal representative after the testator's death. They'd have to produce the death certificate as well as an identification, and we keep those sealed in a safe. Again, someone needs to know it's there. I mean, we do, when someone's file, do a name search, but there are some sitting there that clearly are from, you know, 1960, and probably are just sitting there well past the testator's death. We also have the omitted child statute. If you have a child you're not leaving something to because you provided them something during their lifetime, you have to say that specifically in a will. You can't just leave it to 2 of your 3 children and let that be. It's called the omitted child statute. You know, even he left his son $1 in the will and said he left it that's all he left them purposefully, then that sticks. But if you don't mention it at all, that you leave someone $1 in your will, a child $1 in your will, that child can come in and get their intestate share as if you died without a will, and they would take that portion. Also, people leave specific devices like a picture or jewelry, and sometimes they do that in a memorandum. Now your will can either list them specifically, or it can reference a memorandum that your executor would then have to be know where that is and to distribute your things. Like my mother has 8 children, and we certainly all think that we're her favorite, and we all think that we should have that beautiful crystal vase that she has, and it's really going to go to me, I've decided. But you know, everyone thinks that they have something special that belongs to their parents, and the last thing you really want to do, I'm sure, is to leave your children to fight over that one piece of property, because what happens when we see so often is people determine how much someone cared about them by what they're left, and that's not always the case. But the best way to alleviate any of your, like all of your children's concerns, is to definitely provide as specific instructions as possible, so that there's no will contest and there's no fighting over your estate after you're gone. You know, families fall apart in our court all the time after the fact, and it's just unnecessary. You know, $100,000 is a lot of money, but you know, split 5 ways, it's $20,000 a piece, and that's what they're fighting over. It's sometimes very hard to watch that happen to families. So the more specific you can be, the more you save your family from you know, some of these feelings of anxiety and frustration with each other. You know, we had 3 very popular cases, or publicized cases, I should say, that really come into effect with the probate and family court. And I just wanted to give you a little bit of a touch of these cases. If you all know the Tevi Shrivo case, I don't know if you remember this. It was a young woman who was married. She was in a car accident and was, in essence, brain dead. And she was, her parents wanted to keep her alive on life support, and her husband, after a long period of time, did not. And there was a battle, and it ultimately went to the Supreme Court. And they decided that, yes, the next of kin was the husband, and the husband was the one that was given the right to determine what to do with her life. And I tell this story briefly because if you have a healthcare proxy and you have a living will, you are protecting yourself from someone else imposing their wants or their conditions on your life. Just as we talked about the will and intestacy, the same holds true for your health. So the more you can estate plan, and that is not just money, that's for your future care, the better. We talk about Joan Kennedy, and if some of you remember the Joan Kennedy case, she owned a home. Her children tried to put her under guardianship because she was an alcoholic. And she had this beautiful home that they all wanted to keep with the Kennedys, and she wanted to sell it. And she sold it for an undisclosed price to a third party. And they came in and fought it, and saying that they had guardianship over her. But they did not win that case because she was protected by a trust, is how I remember it to be. So creations of a trust can protect your assets during your life. And when people are coming in, and you know, as you get older, people say it all the time, senile, dementia, you know, all these things that they try to put on you, even if it's not true, it happens, especially with the nursing homes. So I bring up the Joan Kennedy case because the Uniform Probate Code also involved guardianship cases and conservatorships. And what the law did, and this was enacted a couple of years ago, was create the ability to limit a guardianship. It used to be that if someone came in and wanted guardianship, or someone agreed my child would be better taking care of my doctor's appointments and everything else, you gave guardianship, but that guardian then took over everything. They actually had the rights to do everything. Choose your clothes, choose your home, choose the toothpaste you used. What the guardianship law did now was limit that. So someone can come in and seek a limited guardianship, whereas the person is is capable of living by themselves, dressing themselves, keeping themselves clothed, but it gives them power over, let's say, scheduling just their doctor's appointments or dealing with their medical issues. And that was a limitation that wasn't available prior to a couple of years ago. And also, what the guardianship law did was require specific orders from the court to admit someone to a nursing care facility. And when that happens, a counsel is appointed for the ward, is what we call an incapacitated person under guardianship. And the court appoints a third-party attorney who visits with the ward or potential ward and the doctors, and figures out if this is really what's best suited. And that's an attorney for the ward themselves, as if they hired them themselves. If there's no money in the state, it's paid for by the Commonwealth. If there is money in the state, obviously it's paid through the estate. So another reason why you should protect your assets in a trust. But these are conditions now on guardianships that make it a little more difficult for individuals to come in and assume themselves into someone's life. Also, you know, people going to the nursing care facility now for limited short-term physical recuperation. what's it called, physical therapy, let's say. If someone is under guardianship, they used to have to come in and petition again that specific responsibility, even if it was for short-term care. Now there is the ability just to put a filing in the court. Counsel again is appointed to go look at the situation, and if it's less than 60 days that the person's going to be in there, they don't have to file a full-blown petition if someone is already under guardianship. So that was a way to simplify the process for people that were in acute care in a hospital, still needed further care in a nursing facility, but not be admitted into the nursing facility. I bring up the nursing facilities because, as I'm sure you are all aware, as most seniors are, when I go out and speak, of the 5-year look-back period for Medicaid. And the MUPC does nothing to protect you any further than you already are, or grant you, it doesn't grant you any further protections against Medicaid reaching back and taking your property and making you a pay day-by-day patient at a nursing care facility. I'm sorry, I lost my train of thought. So we talk about this 5-year look-back period and ways to protect yourself. We talk about trusts again. Revocable is when someone creates a trust that they can still have control over the corpus of the trust, which is, let's say, a house. Or an irrevocable, where they've given up all rights to actually reach into the trust and control the corpus of the trust, and has given it back to the, given that fully to the trustee. An irrevocable trust can help you from the 5-year look-back period if you own a home. If you have personalty, that is monies in your trust, you need to go and protect yourself further, because your trustee can make payouts to a nursing home facility out of that trust if it's personalty. So I think sometimes people get confused that a trust over all my property is going to save me from having to pay a nursing care facility, and that's not the case. If there is money in that trust, revocable or irrevocable, you will be a payee of the nursing care facility. There are ways to protect yourselves with an estate plan that take the corpus of your trust, if it's a personalty, meaning money again, and put it into different investments that you're only able to get the payout, the interest, or the payments out of it, but not be able to do anything with the corpus. I know a lot of you probably have retirement plans, and if you've set yourselves up with beneficiaries, then you've done a great service to whomever your beneficiaries are. If you haven't done that, I would recommend that you do, because that keeps that out of probate and family court. And although we've made the rules a little simpler for filing, you do want as much as possible to keep your estate out of probate court. Again, it is a public court, so people can come in and look at your will after the fact, whereas a trust doesn't necessarily have to be filed at any time in the court since the passage of this MUPC. So, you know, I know the goals of trust are to keep your information private, protect your assets, and that is what happens now under the MUPC. It used to be that if there was a trust left in a will, you would have to file that trust with the will. You no longer have to. Also, the requirement to do an accounting every year. You know, your executor or executrix was required to account to the court what happened to the monies in the estate and what happened with the distributions. Under the MUPC, that requirement is no longer a factor, nor is supervised estates under the court. So that means someone comes in, gets appointed, the family's perfectly happy, the will is what the will was, everybody knows that was what mom wanted. They can go about their business, distribute the estate, and everybody leaves with no other requirements to come into the court. And that is a huge relief to the personal representative, and it's a huge savings, as a matter of fact, to the estate, because we make most of our money in Middlesex County from the filing of accounts on estates cases. I think we make almost $750,000 a year. So, you know, we're going to take a hit in the money, but it's going to save your estate, and your money is going to go to the people that you intended it to go to in the first place, which was your family. So just a quick overview of the MUPC changes were the limited guardianships, limited conservatorships, which was over the money, requirements for medical certificates to be filed that were, they're about five-page documents that are required to be signed by your doctor. And that's required to be filed, let alone for the guardianship to be allowed. So that's been a hit to some people who come in and petition. It used to be you could come and petition, get a temporary, then go out and get the medical certificate, and that's no longer okay. So if that person didn't have standing to come to your doctor and get that medical certificate, they're not going to be able to come to the court and request it from the court either. The other part on the estates and trusts are the change to the intestacy laws. I think it really acknowledges blended families. I think it secures a spousal rights in property if someone dies without a will. I also think it alleviates the fiduciary from having to file the accountings and have the supervision of the court over the distribution of the estate. And I think those are really the primary, most, will affect everyone across the board, the best changes for the MUPC. And we do have a way of filing now informally. It used to be that you would file, have to wait 30 days, publish in a newspaper, then come back and get your appointment. There is now a way to file informally, and all that requires is notice, 7 days notice to all the heirs at law prior to filing, and you should be able to be appointed right after that. And then you do a publication of your appointment after the fact, which is smaller and cheaper. So I think that's a benefit again to those families that are all in agreement as to this is what the will says, this is what my parent wanted, or this is what my child wanted, as the case may be. And if a family's in agreement, that's what they get. So again, the whole goal is to keep the court out of your business and to keep the state off of your money and let you decide what you want to do with your life's work. I just want to kind of end on, the Ted Williams case. And I know you all know who Ted Williams is, but if you all remember when he passed away, he had a will, and his son was the executor and had determined that they would cryo-freeze his head and body. And there's other people that said that's not what he wanted. And in fact, unfortunately, for Ted Williams, he didn't add a codicil to his will. What he did was take a, do you have a copy of the check? What he did was write to his attorney and specified what he wanted. And this was a big legal battle. I think you all remember it dragged on for a very, very long time. And I just want, if you'll indulge me, to read this letter to an attorney. It's dated December 19th, 1991, and it's to an attorney in Boston that says, "Dear Bob, this letter is to confirm our discussions over the years relating to my desires for funeral and burial arrangements. I feel strongly about what I want and do not want, and I hope you will make my wishes known to Louise and my family at the time of my death. It is my wish that no funeral memorial service of any kind be held, and that my remains be cremated as soon as possible after my death. I want you to see that my ashes are sprinkled at sea off the coast of Florida, where the water is very deep. Naturally, I understand that others may want to have some sort of memorial service, but I do not want it sponsored by my family or you, my friend and professional advisor. From time to time as we talk, I will give you further details, but for the moment, I want to document my present thinking." Unfortunately, Bob failed to write up a codicil and have it signed and notarized and added to Mr. Williams' will. And as we all know, his son was able to succeed in litigation, and his body was frozen. And unfortunately, this letter, which was on file because it was part of the case, didn't have the weight that I think the attorney thought it would. So I hope you take that as a note. If you have something that you want done, put it in writing, get it attached, not just in writing, put it in writing and get it made part of your last will and testament. It's so important to protect yourself and your family with these trusts and with these healthcare proxies and living wills. I mean, these tools are out there for you. I know I've been talking generally and kind of filling you with a lot of information here and there, so I was going to open it up to a question and answer session. If anyone has any questions, I'd be happy to answer them. If they're pretty specific or detailed, I may ask you to wait till the end or refer you to Jack. Jack is my legal counsel over at the Probate and Family Court, and you know, I know enough when I have to stop and the experience takes over. So if anyone has any questions, I'd be happy to answer something.
When would you need a new will as opposed to just a codicil?
When would you need a new will as opposed to a codicil? If you're making, you know, you have 5 or 6 codicils, I think I would definitely write up a new will. If you're adding or amending a certain paragraph or a portion of your will, you really don't, the codicil is fine. If you have an extensive will, I mean, that's where these codicils are more helpful. If you have a 3-page will that is pretty direct, you know, it might even be better to do a new will. It really depends on your case, but the codicils become part of the will, so it actually is a new will once the codicil's there. But as you get 1 or 2 or more, you have to start referencing, everyone has to reference my will and first codicil. Okay, my will and first and second codicil. And you have to put the dates in, and there's kind of specific language that you need to use. So as you make changes that are either really extensive, or there's a number in a row, you want to change that. Also, if you do write a new will, really destroy the old one and all the copies, so there's really no question as to what your intent was. The only way to throw out a will is through showing a fraud, undue influence, and what's the other one, Jack? I can't. Thank you, incompetence. And mistake, thank you. Go ahead, I'm sorry, sir.
Why does it take so long to probate the will in Massachusetts?
Well, I think the problem with probating the will in Massachusetts really is the accounts period. So a estate is never really considered closed until the final account is adjudicated or approved by the judge.
What do you mean by that?
So if someone passes and they're appointed, that's not really just the end of the estate. Now, the will is accepted as the last will and testament, and the appointment is made and the fiduciary's bond is approved. But under the old law, you used to have to file an accounting. It was required to file an accounting every year. We're not in the business of hunting down heirs, but your probate estate is really never ended. And when you file an accounting, there's a filing fee, and there's also a sliding scale. So you can pay up to $1,000 per account based on the amount in your estate. So a final accounting would be, I've distributed all the money here. This is what was in the inventory. This is Schedule A, everything that was on hand when I took over as fiduciary. Schedule B is this is everything that went out and who I distributed to, and there's 0 left, and that's my final accounting, and the judge looks at it. If no one objects, it's approved. So I think when you talk about the probate, why probating takes a long time, the completion is that period. If you're talking about just the appointment period, it's really because people come in and they have to publish in the newspaper, and they have to notify all next of kin, all heirs at law. And a lot of the times they fail to do one or the other, or they leave someone out, or they forget, oh, you know, even though I have 2 siblings left, I have to let my niece and nephew know, and oh, the nephew that passed, their children have to know because of the way the heir at law statute is. So I think a lot of the times there's a failure to perfect notice, and then the appointment comes after that. So if you do the informal now, you will get your appointment within, if we had enough staff, you would get your appointment within a week of filing. But there isn't enough staff, so it's really 4 weeks out from the date you file. An informal. For a formal, it's probably 2 months out.
This stay is 3 years.
Do you have the docket number? All right, I'm gonna have you give Jack your information and, or Rayanne your information, and I'll contact you and look it up. No one's been appointed on the estate?
Yes.
They have been. If someone is appointed on an estate and is supposed to have done specific things and you don't know what's going on, you can come into the court and as a beneficiary are protected in that you can file a petition to render an account. And just the filing of that creates an order from the court that goes to the fiduciary that says you have a certain time period, and I think it's a month, to file your inventory and file your accounting. And they do that, and when they file that inventory or accounting, when they file their accounting, you then as a beneficiary, if you don't agree with it, have the right to object. And that will then bring it in front of a judge. So that might be where you're at. If you're saying the case hasn't, the estate hasn't been closed because distributions haven't been made, that means the fiduciary is not performing as they're supposed to be. There's also ways to remove the fiduciary, but I think the first step is the accounting, rendering the account. Okay? You first and then you.
Do I have should a person have a will made up by an attorney, or can he make up his own will, and which so he has to do to make it legal?
I'll tell you, I always advise people to go to an attorney because estate planning is so complicated. And if you have a $500,000 estate, it is really worth the money to get it protected properly. I can't say, especially in the state, that you should be doing it yourself. However, the things that I mentioned in the beginning, those were really some requirements. The signing, the initialing of each page, the witnessing by 2 people. And again, if either one of those 2 people take under the will, that's going to throw your will out. The notarization, you know, if you have any omitted child statute, there's also the spousal elective share. So if you have a spouse and you don't leave them something, they can actually try to fight the will and get what their elective share would be. So you have to really, you don't have to see an attorney, but I cannot recommend, I recommend that you do. And really, there are estate planning attorneys that they know how much an estate is. I don't think they're, you know, they come in and they ask for specific things. They give you pieces of paper that you have to fill out that says what's in your estate, who are your family members, and they kind of, what are your goals, and they do your will. I mean, simple wills really are not as expensive, I think, as people think. Trusts, now that can be another story because to protect your assets, there's a lot of different things that need to be thought of, and I'm not an estate planning attorney. I don't know all the details of those, but I do know that the tax, protection from taxes, ways to protect from Medicaid, it's all complicated and it changes all the time. So that's my recommendation.
Is there some procedure to go from a will to a trust using a different attorney? I have a will now, but I don't want to use the same attorney because I have to wait over 2 years for the estate to be probated. Plus, there were certain things I wanted him to put in my will, and he didn't do it. And he didn't have the initial anything like you said. And also, there was something that should have been taken care of at that time. He didn't do it, so I'm going to be using a different attorney. And I'm just wondering if that would create complications.
So what happens now is, like, if you have a will, obviously you're not deceased, so you can have a will. You're talking about 2 different things. There's 2 different ways to create a trust, and that's an inter vivos trust, which is one that's during your lifetime, that's revocable or irrevocable, and there's a testamentary trust that's created through your will. Now, your will can leave everything to the trust that's already created, or it can create it. So when you're talking about switching everything from a will to a trust, it just doesn't really work that way. It's really going to sit with an estate planning attorney. And I would think that an attorney that is a wills attorney isn't necessarily an estate planning attorney. Would you agree with me, Jack? Yeah. Because trusts, like I said, are very complicated. If you have an inter vivos trust, and you pass, and your trust has language of what should happen to the trust at the time of your death, you don't even have to probate your estate if that contains all of your estate. So a trust really can protect you from estate taxes and give more money to your descendants, and, you know, yeah, I think that if that's what you want.
Just make a will obsolete, can I just do that?
Correct.
And then just start over with a trust?
Yes.
Yeah, I think that might be better.
I mean, honestly, destroying your will is, if there is no will, there is no will to probate, but I wouldn't do that until, you know, depending on what it says, if it's really what your wishes are. If it's better than what the intestate law would be, I would not do anything with it until you create.
You don't have to go through probate, right?
If you have a trust and it's drafted properly, and all your assets are in there, you would not have to go through the probate court, right? Yeah, and I had something else to say, but left my mind. The only time that would ever come in the probate court is if there was a trustee that wanted to account. Like, we have some of these, honestly, multi-million dollar, like, cases where they've been going on for 50, 60 years, and a corporate trustee is in place, like a Bank of America, and they file every year the trust, the accounting, just to say, just to put it on file. But other than that, it doesn't, that trust would never have to come in. Unless someone didn't do an accounting and they could render an account, or request the trustee render an account. They're protected in that way because last month they passed the Massachusetts Uniform Trust Code, which kind of just codified a lot of the laws that were in place, but, you know, also let the trust indicate what should happen. You don't have to come into court to seek intervention, but it does give you the ability to come in and get an accounting done if you're a beneficiary of a trust and the trustee is not doing what they're supposed to be doing, what you think they're supposed to be doing.
Thank you very much.
Go ahead.
Well, just to clarify, if trust is set up in your lifetime, so it's an in vivo trust, we call that?
Inter vivos, yeah.
Could that do the whole job of a will? Could that obviate the necessity for a will?
It could.
You set up a trust, everything's in the trust, and that's the end of it. I'm just asking.
Yeah, it could, because it all depends on how it's drafted. Now, if it's drafted to deal with what happens to the assets at the time of your death, then absolutely, that's the benefit of, one of the other benefits of a trust.
So a trust has an integral will, in effect. It's got the will built into it.
It can, yeah. Some people don't, and I don't know why you go through that process and not, but yeah. And some people, you know, not all their assets are in the trust, so they would have to probate so that the residuary of their estate is then poured over into the trust or given to particular people. But yes, a trust can obviate the necessity of a will, probating of a will. Yeah. I'm sorry, in the back?
Okay. Once a probate is completed, do you get a letter of notification either through the attorney or directly from the court?
If you have an attorney, right now it used to not be automatic, but under the new fee schedule, a letter of appointment issues, and the letter will go directly to your attorney if you're represented. If you're not represented, it will go directly to the petitioner.
That it's been completed?
That has, yeah. And if it hasn't, you'll get a copy of the order denying it. And if it has, then you'll get the letter of appointment.
Not of appointment, that the probate has been completed.
You mean the final accounting?
Exactly.
Your attorney will get a copy of the final judgment, yes.
Okay, good.
And it will be a judgment on a final account. It won't, first and final, 25th and final, first through 25th and final, because some people don't file every year, and then they'll give us 25 accounts in 1 year and want it to be final, so.
But there is a letter of closure?
There is, yeah, it's a judgment, sure. A decree, I'm sorry, it used to be a judgment, it's a decree now. Go ahead.
Simple question. On a trust, I have everything in the
No,
trust.
so no questions.
Except the car. That's it. That's not in the trust. Can that trust just stand alone?
Yeah, the trust will stand alone, and then the car, the person who is your heir would have to just come in and get a voluntary. We have anything under $25,000 estate, not including a car, would be a voluntary statement. Nobody's appointed, but an interested person, an heir at law can come in and they list all the assets, the car being one of them. It happens frequently, so they can change title And they'll come in and get that, and they'll be able to go to the registry and get everything that they need to get done to transfer the car. Yeah. You said something, and it rang a bell with me when we talk about the trusts and the property. And I'm sure a lot of you that are married probably own a home, and you know, some ways that the people protect themselves is to own the home as joint tenants with rights of survivorship as opposed to tenants in common. Now, I was just approving an estate today. The individual deceased in 1992, he owned a house in common, not with rights of survivorship. They transferred the estate, they transferred the house, and there's a cloud on the title because they never probated the father's will, and so the asset never, the daughter, the husband, I'm sorry, the father and the daughter owned it as tenants in common. That doesn't come with rights of survivorship. So when the father passed away, that had to be probated, that portion of the house, to transfer the house into the daughter's name. And so, as opposed to a joint tenancy, whereas it would have transferred right upon death to the daughter to dispose of. When she sold it, now it has a cloud on the title, and they're coming back at this late date to try to clear title. So joint tenancy is a great way to just let that initial transfer happen. And even if you have those I love you wills, where like one spouse leaves everything to the other and the other spouse leaves everything to the other, at least on the first case, you wouldn't have to come into probate. So sometimes, even though you have assets, they transfer outside of the probate, like a beneficiary or a joint tenancy or a trust. Yeah. I'm sorry? You have to check your deed, and in Winchester it would be the Middlesex South Registry of Deeds, and that's available online. You can look it up by name or address. I think it's masslandrecords.com. And you can research your property, pull up your deed, and see if it's held as tenants in common. So, anyone else?
I had some questions about the personal representative.
Okay.
One, can the personal representative be a resident of another state?
They can. Now, they don't need an appointment of agent. Your executor could live in Arizona.
Does the personal representative, once appointed, receive a document from the court saying that they are the personal representative?
Yes, they'll receive a letter of appointment. If they're represented by counsel, counsel will receive it, but it'll go to one or the other.
Another question. Could you give a definition of heirs at law? What does that mean?
Heirs at law, it's lineal. It used to be per stirpes, but now it's lineal. So if you have a spouse, they're your heir, and just children. I'm sorry. If you have a spouse alone, no children, and you have parents, then the spouse and parents are your heir at law. If you have a spouse with children, even if the parents are alive or not, and it's just the children of the marriage, your spouse is the heir at law only. If you leave no spouse and just children, then your children are your heir at law. And it goes down lineally. So it goes, if you have no children, no spouse, it'll go up to your parents and then down through your siblings, and then your siblings, your nieces and nephews, so your siblings' children. And there is a statute, and I'm sorry, I can look up the reference before I leave and I can give it to you, that kind of lists them all out. And if you go to our mass.gov/courts website, you can look at the forms for probate, and it kind of, in question number 5, it really tells you what the list is right on that petition of how the lines go. And if you have no nieces and nephews, then it's next of kin, like cousins and things like that. Oh, sorry, it would be grandchildren. It goes down and then it goes back up. I apologize. And now, you brought up a good point that it just left me because I'm kind of doing this off the cuff, was that it used to be when someone died without a will, and let's say they had 3 children, 2 were living, 1 deceased, and they had 2 children, that the 2 children would take their parents' share, the deceased parents' share, your deceased child's share. What happens now is they do it lineally. So if there are 2 children I'm sorry, if there are 3 children, 2 deceased, and let's say there's 5 grandchildren, 2 of them are the deceased child's, that deceased child's share gets divided up between all of the grandchildren, not just that deceased child's children. And the thought when they changed that is that, so it's by representation, it's not per stirpe. So what that did was, why they did that was they said a grandparent would want to leave equally to all their grandchildren on the same level. If you're on the same rung of the ladder, you're all being treated the same. You know, these grandchildren are not going to get more of the grandparents' estate. That was the thinking behind it. So if that's not the way you like it, you got to make it different in the will. So, go ahead.
That deceased child might not have children. Would that share go to spouse or not?
If there's spouse and deceased child, it would go to the spouse. If it's an intact family. If there's no surviving spouse and just children, their share, if they have no children, would be divided amongst their siblings. So no surviving spouse, 3 children, 1 deceased. The 2 living children would take that child's share. If there was no grandchildren of that deceased child. This is all predicated on no surviving spouse. Or now a case where there might have been a child of a prior relationship. So they're treated all the same. Anyone else?
Would you differentiate between per stirpe and by right of representation?
Yeah, it used to be that per stirpes was if you had the 3 children and you had 5 grandchildren and 2 of them were from a deceased child, the 2 children that are living would take their share, and the 2 grandchildren of the deceased child would take the deceased child's share. So if there was $30,000, 10 would go to child A, 10 to child B, and then the 10,000 would be divided between the deceased child's children. What happens now is child A would get their share, their 10, child B would get their 10, but now the 5 grandchildren would all get $2,000 each.
Now that's per stirpe?
That's for representation. Yeah. All right. Anyone else? Okay. Thank you so much for having me. I really appreciate it. It was a great day. Thank you very much.